Good afternoon, everyone, and welcome to the Assembly Committee on Commerce and Labor. Ms. DiMarzo, please call roll.
Assembly members Anderson. Present. Carter. Present. Cole. Here. Hardy. Here. Howdigi. Kasama. Miller. Here. Monroe Moreno. Here. O'Neill. Here. Roth. Torres Fawcett. Here. Yeager. Here. Urick. Here. Chair Marzola.
Here. Please mark Assemblymember Kasama absent excused, and please mark Assemblymember Howdigi present once she arrives. Welcome everyone who is here with us in Carson City, those joining us by video conference in Las Vegas, Nevada, and those tuning in over the internet. Today we will hear three bills: Assembly Bill 198, Assembly Bill 202, and Assembly Bill 211. I will not be taking those in order. Before we get started, I would like to make a few housekeeping announcements. Members of the public may provide testimony in various ways, all of which are listed in our agenda. When testifying, please turn the microphone on to speak and off to listen. Also, please remember to state and spell your name for the record. If you have handouts for the committee, please provide 20 copies to the committee secretary prior to your testimony. In addition, exhibits and amendments must be submitted electronically as a PDF file to our committee manager no later than noon on the business day before the meeting. Committee information is available on Nellis, which can be accessed through the legislature's website. You may also watch our meetings through Nellis or the legislature's YouTube. We ask that public comments be kept to 2 minutes so that everyone interested in speaking can be accommodated. And this also ensures we can get through the agenda in a timely fashion. Public comment may be submitted in writing, either in addition to testifying or in lieu thereof. Written public comment may be submitted before, during, or up to 24 hours after the meeting has adjourned. I expect courtesy and respect in all our interactions, even if we may not agree. Finally, please put your electronic devices on silent, especially your cell phones. And with that, we will move to our first agenda item. Assembly Bill 211. This measure revises provisions relating to substandard properties. Assemblymember Considine, welcome. And you can begin when you're ready.
Thank you, Chair Marzola, Vice Chair Howdigi, and members of the committee. I am Venetia Considine, VENICIA-CONSIDINE, and I am here today to present Assembly Bill 211. With me in Las Vegas is Clark County Commissioner Tick Sagerbloom, and here in Carson City, we have Government Affairs Manager, Clark County, Joanna Jacob. AB 211 provides a solution to the extreme situation when a property is significantly substandard and all attempts to bring the property to standard are rebuffed, ignored, or the situation is where the owner is unable to bring up the property to code on their own. These are situations where seniors are crawling up the stairs or trapped in their unit because an elevator has been inoperable for months, or when the owners have determined that paying a fine is more acceptable than the option of fixing the property. Under law, landlords are required to maintain a dwelling in habitable condition, and the law delineates violations concerning the health, safety, sanitation, or fitness for habitation. AB 211 gives authorization to bring an action to require the property to be brought up to standard, including to appoint a receiver. This is when the condition of a property is of such a nature that the health and safety of residents or the public are substantially endangered. This is not an instant fix. This does not start with a notice to do a receivership. The bill has two parts, which are essentially the same. Sections 2 through 18 are county-specific, and sections 21 through 37 are city-specific, but the provisions are the same. I'd like to go through the bill. We do have a conceptual amendment that you should have a copy of, but I will submit it to Nellis after the hearing. Sections 8 and 27 describe the process where an appropriate department finds that a property violates standards to such an extent that the health and safety of residents or the public is substantially endangered. There may already be a pattern of communications between the enforcement agency and the owners, but this section explains the notice process and requirement of the notice and the posting. In this section, we have met with stakeholders who have requested that we remove Sections 8.2b2 and the corresponding Section 27.2b2 that require the standard mailing and posting in practice. We have included removing that to use the standard mailing and posting in practice as requested by some of the stakeholders we met with. Sections 9 and 28 only occur when the owner of the property fails to comply with the notice, abate the condition, or work out a plan with the department. This section provides the ability to bring an action in district court to declare the property substandard. So I just want to be clear that this is after the enforcement agency or code enforcement has gone out multiple times. They've reached out to folks. This is already after months of trying to work to fix the property. Now, this is the notice part where the property owner fails to comply with the notice, abate the condition, or work out a plan with the department. So they have all of those options. This section provides the ability to bring an action in district court to declare the property substandard. It is the district court who must determine if the property is substandard. If the district court finds the property of substandard, only then can the court appoint a receiver. Again, after speaking with stakeholders, we are revising a couple of these sections. Section 9.2a and the corresponding section 28.2a right now provide a 3-day notice. We've been requested to change that to a 30-day notice instead of a 3-day notice. We're fine with that. This was requested to ensure some owners or landlords would receive the notice. For example, if the notice would go to a resident agent or if the owner is out of state or out of country. This change is in line with NRS 244.3605. We are also revising sections 9.4 and the corresponding 28.4 to say that it's the court's discretion to award attorney's fees and costs. And these are in the conceptual amendment. Moving on, sections 10 and 29 list the findings that are needed to be made by the district court before it can declare the property substandard. Also, the consideration to appoint a receiver and where appropriate, the appointing of a receiver. Sections 11 and 30 describe the next steps the district court would take, including reasonable and actual costs to the county or city, order that the notice be given to each tenant, and in cases where the repair, rehabilitation, or abatement affects the safe and sanitary use of the property, order the owner to pay relocation costs if the tenants cannot remain in the property while it is being fixed. These sections also require the owner to offer the first right of occupancy to tenants that are removed once the property is fixed. Sections 12, 13, 14, and the corresponding 31, 32, and 33 go over the receivership abilities and responsibilities. Sections 15, 16, 34, and 35 cover discharging the receiver. And sections 17, 18, and the corresponding 36 and 37 include language to ensure that the previous sections do not limit the rights available under any other provision of law and are not intended to deprive any owner of a residential property or substandard property any right guaranteed by the U.S. or the Nevada Constitution. There are more than 20 states that already have laws for this process on the books. We have met with some of the stakeholders resulting in the conceptual amendment and will continue to do so. I know that was really fast to go through a bill that is kind of long, but I wanted to just give an overview of the different sections. So I had a moment to talk about, again, that this is not an instant fix and this is not an instant process. This is only used or would be used in extreme circumstances when every other attempt to abate, fix, work with the property owner has been exhausted. There are a couple of examples of this, which we will go over. And before I turn to questions, I would like to turn it over to Commissioner Tick Sager-Bloom in Las Vegas.
Good afternoon. I can't see anyone up there, but hopefully you can see me. Thank you, Venetia, and thank you. I'm so proud to work with her on this bill. Let me just give you a brief example of what we're dealing with. Large apartment complex, about 200 tenants. The product or the facility becomes intolerable for some of the people. We reach out to the landlord and say, can you fix these units, fix this pool, whatever. They're out-of-state landlord. They basically just stiff us, ignore us, and say at the end of the day, after months and months of trying to work with them, close us down. I have 200 tenants. They're low-income tenants. I don't have a place to take 200 people and put them in another unit. I mean, if I had that, this would not be necessary. But I have 200 people who in a building that is actually can be fixed, and the landlord refuses to fix it, refuses to do anything, and just basically says, shut us down, we don't care. This is the situation we're dealing with. So because there's no other alternative, the solution would be obviously for us to step in, manage the property ourselves, fix it up, and keep those 200 people in their unit as opposed to putting them on the street. We don't have that ability. We went to court. We're working with court with the judge, but the judge cannot micromanage a process like this. So this is a very extreme thing. This particular bill I'm talking about, 2 people died, were shot to death in the unit. There were drugs being dealt there. I mean, it was terrible, but the landlord basically said, we don't, put us out of business. We're not going to do anything. And that's unacceptable in my opinion. And we don't have the ability to take those 200 people and put them anywhere. So this gives us the tool. It's the final resort. Hopefully it'll be even a lever which we would never have to use. But at the end of the day, we don't want to put 200 people on the street. We don't want to shut this property down. And so I thank Venetia for bringing this bill. It's so necessary. And if you have any questions, I'd be happy to answer. Thank you.
Thank you. I just want to reinforce that this bill is an extreme response to an extreme situation. It allows jurisdictions to ensure the health and safety of their communities. It keeps property values from decreasing and sets out a clear path to resolve substandard property issues at several stages prior to going to the district court. This bill is about bad actors and those who cannot afford to fix their properties. That's it. At this point, we would be happy to take questions. Thank you.
Thank you for being here today and your presentation. I believe we have several questions. We will start with Speaker Yeager.
Thank you, Madam Chair, and it is good to see you, Assemblymember Considine and Ms. Jacob and Commissioner Segerbloom. Always good to have you join us. This is just the kind of bill that, frankly, I'm horrified that we have to deal with something like this. If people would just be good to one another and realize that we all have dignity. I mean, the story that was just told of people living in these places is quite frankly horrifying. And I'm not going to try to amend your bill, but honestly, I think it should be criminal in some sense. If someone is aware of the problem and unwilling to fix it, that's unacceptable. But, I applaud you for trying to solve this problem. And I guess my question is, Commissioner Segerbloom explained it a little bit. The issue just seems to be when you have that many people, you can't just move them somewhere for the property to be fixed. And so he gave a good example, which I'm imagining is probably a very egregious one, but I just wondered if you could speak to, at least in Clark County, how prevalent this problem is, because as we're talking about housing this session, we're always talking about those who can't stay in their homes or their apartments. But I think this is a segment we rarely think about, the people that are forced to live in substandard housing, which, obviously is an affront to their dignity. So could you just give us a sense of the magnitude of the problem we're looking at? Thank you.
Thank you, and through you, Chair Marzola, to Speaker Yeager.
You can go direct.
This is Joanna Jacob, JACOB, for the record, on behalf of Clark County. And I know Commissioner Segerbloom can speak to this. I know it's impacted multiple properties in his district. He's done a lot of work. I am a county employee, so when I am not here before you in the legislature, I work in the county building with the board. And I am aware that this is, I often say this kind of code work that the commissioners do is the bread and butter of what they do. Their staff gets contacted, and often we're contacted because there is no place to contact for this type of thing. I spoke to one of our another commissioner's office this morning, who's currently dealing with a 400 unit facility. that the health district has been out multiple times. They found, I don't want to be disgusting, but they found a pool that had been improperly covered. Feral cats got underneath, and they found hundreds of dead cats that were in the pool. There are multiple occasions. There's been homicides at that property. It comes to us frequently through calls to service to Metro, and then we are trying to engage and trying to figure out how to improve the conditions for the tenants. That is one commission example, but it's impacting multiple commissioners, and Chair Segerblum can probably speak to this. We've been working on this for a number of years, trying to figure out if there was a legal remedy that we could get in there faster, especially you mentioned, Speaker, the attention that comes about housing availability and the conditions that we have in Clark County. It is a significant concern when we have units of that buildings of that size that we might have to relocate tenants. It is a challenge for us, and one that we do think our code enforcement officers do try to work with landlords. You may hear that sometimes it's a challenge. This is only, like Assembly Member Considine said, after months of work where we may try and address, and sometimes we are able to work with the landlords, and with the code enforcement, we'll work with them on a plan. And this is only where we cannot get participation. So it happens frequently. Happy to give you more. Any committee member wants more examples, happy to do that. But I do want to emphasize this is not just in Commissioner Segerblum's district, but in multiple districts, which is why we wanted to work on this bill in this legislative session.
Committee members, any additional questions? Assemblymember Cole.
Hi, thank you for your presentation. I have questions on probably several different areas, but I'll just stick to the one. So it's in section 10, and there's obviously one on the city side, but I think my concern would be just to make sure that this doesn't sweep too broadly. Having the court see the record that you're discussing where, whatever agency, code enforcement has been out in multiple communications, that to make sure that's part of the record that the court is considering, to make sure it's not just a one-off kind of thing. I know that's not your intent here. One question on the code violations. Are we talking about code violations of today's code or violations of code when the building was built? Because I know those can change. For instance, fire sprinklers in houses that are over 3,000 square feet are required now, but they weren't, say, 20, 30 years ago. And then I would like to see a definition of what substantially endangered means. I didn't see that. I might have missed it. And then I'm just a little concerned about how broad the discretion is in 10(1)(c). It just seems like any other factor that the judge considers. So that might just be too broad for me. But I can give you written comments later on some of the other things too. Thank you.
Venetia Considine for the record to Assemblymember Cole. I just want to clarify under section 10, 2B, the court is required to consider whether the owner of the substandard property has been afforded a reasonable opportunity to repair and rehabilitate the property and otherwise abate the condition. So I think the inference in that is that there would be a history of what was happening to the property prior.
Okay, so maybe that takes care of that part then.
Joanna Jacob for the record. I guess in response to Assemblymember Cole, we've looked at other states who have this. We mentioned 20 other states have it. And in other states, procedurally how this works is that if an action were filed in the district court, it's accompanied with an affidavit with the narrative of exactly the case history. So that is frequently considered and then served on the other side. So that all of the record, as you mentioned, is part of the consideration of the court. So we know that, and that is how it works in several of the other states where this process is in place.
Assemblymember Torres Fawcett.
Thank you, Chair, and thank you so much for bringing this piece of legislation to address this issue. So I was just looking specifically at where I think it's section 10, I'm looking at page 5 of the bill, just where you speak about the nonprofit organizations. What type of nonprofit organizations would gain receivership for this type of home?
So the court would have to determine, or the receiver would have to determine if any entity is able, Venetia Considine for the record. The receiver or the district court would have to determine whether or not any entity or person who would be having that responsibility is able to do it. So in other states, they do offer the ability for a nonprofit to do it, but those are typically nonprofits that are building houses or rehabilitating houses. It wouldn't just be any nonprofit.
Assemblymember Anderson.
Thank you, Chair, and thank you for bringing forward this language. As I look through the bill and through some other items, there's just some different dates or days that seem to be standing out to me. Like, for example, on page 7, it says 120 days. Another time it says 8 weeks. I'm wondering why some of those dates, why the decision was made to use 120 days or for other things, or if that's simply consistent with other language, possibly in other areas of the statute.
Thank you, Joanna Jacob, for the record. The 120 days that you are referencing, that is it's tied to the HUD rate. If we were, I think, on the cost of the relocation compensation, I believe that may have come from when we were looking at other states. And I can definitely come back and say if there was a particular reason why that was. We modeled this after some of the other statutes that were in there. So I would have to probably go back and give you a written response to that question.
Follow up, if I may? Go ahead. Thank you. So it just was wondering why it was that, because if I'm understanding what happened during, when you were speaking about the information on page 4, this was after months of attempting to rectify the situations. Do we have any sort of idea of how many days that might have been in the past with these attempts to clean it up? Or is that, again, something that might need just a little bit more background research?
This is Joanna Jacob for the record on behalf of Clark County. I was going to see if Chair Segerblum, if you want to talk about how many months it took you on the particular apartment that you worked on. I do know it can depend on the circumstance, but it was a very long period of time.
I want to say, this is Tick Sagerblum for the record. I want to say it's been 3 years and we're still in court, and there's just a handful of tenants left, so they've almost accomplished their objective, but it's still an ongoing problem. And you drive by there and you think, oh my God, how could that be? But again, if the landlord doesn't want to work with it, we need some kind of a lever, and that's why we think this is the way to go.
Follow-up, Chair, if I could. This is Joanna on behalf of Clark County. On the property that I described when I talked about the other commissioner, they have already gone out over, it's been going on for almost a year here. They've gone out for multiple times with the health district and with Metro. So this is not something that we're doing one notice at the property and then all of a sudden we're rushing to the court. The intent, and I will tell you the intent for Clark County Code, my director is not here, but we've worked with him extensively. The intent is to work with the landlord and to make sure that we can maintain the home and fix it, and so that the tenants can remain there. So in the section that you asked me about on the relocation assistance, this is really where we have to now find housing, and that is one thing that where you might have to relocate the tenants or while it's being abated if it's extremely serious. So it varies, but this is not something that it typically there's an attempt to try and go out to the property over multiple months, multiple agencies to try and address the issues.
Thank you, and thank you, Chair.
Assemblymember O'Neill.
Thank you, Chair. Assemblywoman Considine, I am not an attorney, as you well know. I don't want to be one either, but I do have a question in the sense of how much legal or court review can I do just to delay? I'm the property owner of this building, and just to delay this thing out, I want to keep delaying it to go to another court. And I assume it starts out in district court, correct? So I would have to go to the state appeals, which can take years to get a hearing date. That's what I'm just looking at.
Venetia Considine, for the record. Thank you, Assemblymember O'Neill, for the question. I think when you're comparing that process to the process that they're going on now, I believe the commissioner mentioned for 3 years and a year. If someone, I tend to think a lot of these situations are because there isn't the ability to do it or there isn't the desire to do it. If you have to go to court, to district court, you are now paying attorneys potentially, you're paying for filing fees. If the cost to fix your investment is worth the cost, I would imagine spending additional funding to go to appeals unless they are fully necessary might elongate the situation but doesn't resolve it in the long term. And like I said, these are for bad actors, so I don't, these are not for folks who believe that the situation is not what is being presented. That should be taken care of well before it gets to the district court. And at the district court level, if they can prove that their properties are not substandard, it's not a health emergency, it's not a safety issue, then it doesn't go any further than the district court to begin with.
I appreciate you explaining that to me. I thank you. I just know there are some people that just for principle will try to stretch a bad situation out just because. So that's what I wanted to hear, and you answered that. Thank you very, very much. Thank you, Chair.
Committee members, any additional questions? Assemblymember Yurek.
Thank you, Chair. I just want to clarify the intent, and I think I get it here, and I'm specifically looking at Section 10 when we talk about what it takes to declare a property as substandard, and it's specifically referring to physical conditions, the habitability standards, housing codes, building codes that deal with building safety and fire safety. I just want to confirm, is there, based on the commissioner's example, is there an intent to also apply this to, for example, properties where there's high crime rates that might affect public safety? Would these landlords be responsible or held to this same standard for those sorts of incidents?
Thank you. Joanna Jacob, for the record, on behalf of Clark County. Thank you, Assemblyman Yurek. If I understand the question correctly, and I want to make sure I'm addressing it, our intent is to address health and safety issues and the violations of the code where it's dangerous for the health and safety, wires hanging from the ceiling, the health violations that I referenced before. Some of the really egregious things that we've seen in there are sometimes coupled with high crime rate. You know, this may be also because of the condition of the property, there may be also crime there. But this is not the intent of, like, if the absent, this is really for when there is a health and safety violation and a building code violation, that is the intent of why we are trying to bring this, when there's really, it's egregious and the tenants are there and we can't get it fixed. And so I think I want to say no to your answer, to your question, which is, but I want to really make sure that I make this for the record, that sometimes this is combined, the same conditions that we're trying to address, there's also sometimes is combined with crime, and that Metro is frequently involved in these cases because of the condition of the property.
Okay, yeah.
This is Commissioner Sager-Bloom. If I could I follow up on that? The truth is, however, that the police do come to these places, and if they're called out every day and there's a murder there, and they say to the landlord, we need to fix this, we need to fix this, you have some type of security, and the landlord refuses to do that, then that could be, in my opinion, that should be another instance where we have to do something. I mean, what the option is, either shut it down because it's a danger to the tenants, or figure out some way to allow the tenants to stay there in a safe way. And if the landlord won't step up and make sure that they're safe, we don't want to put 200, 400, 600 people on the street for something that can be fixed. And so that's at least is my intention.
Follow-up, Chair? Thank you, ma'am. So yeah, I appreciate the effort to answer that, and I think we are probably heading down the same path, but I'm thinking, for example, of a landlord who's brought in a tenant that they're having trouble evicting for various reasons, and let's say they're dealing drugs, right? And we keep calling Metro to come in and deal with this situation, but it's creating a public safety situation. I don't know that, for example, cameras, to use the commissioner's example, would be something that would be required by code, but if the landlord doesn't comply or put up cameras, are they then subjected to this because Metro's inability to respond and deal, I guess, in a timely manner, that criminal instance, and it's creating a public safety issue, would they be subject to this same provision?
Venetia Considine for the record. I think there's existing eviction laws and processes that the landlord could use in that situation. This is not meant to usurp or go around the landlord's ability to use the existing law that's there to solve those problems. If it got to such an extreme intent that the landlord wasn't trying and it became an extreme health and safety hazard, then I believe that this might be sort of an end option.
Assemblymember Monroe Moreno.
Thank you, Chair. I have a question. Are you finding that you're running into these issues with corporate landlords primarily, or are there individual landlords that maybe have 1 or 2 properties that they're managing and not taking care of? Which ones are you seeing more of in your jurisdictions?
Joanna Jacob for the record. I don't know, Commissioner Segerblum, if you want to try and address that issue. But I will say I don't have like a kind of good sense of whether it's one particular type or not. These are large apartment units. I think I've heard, maybe Commissioner Segerblum can correct me if I'm wrong, but the issue is where we have non-responsive. So someone is out of state and we try and work with the registered agent on their behalf, but the registered agent just says, hey, I'm there to file the articles of incorporation. They're not going to come in and fix the apartment building. Commissioner, do you have anything to add there?
Yes, my personal experience has been out-of-state landlords, so they're not the major
Commissioner,
corporations.
I'm sorry to interrupt you. Can you state your name, please?
Oh, sorry. This is Commissioner Tick Segerblum. So my experience has been they're out-of-state landlords. They're corporations, but they're not large corporations that have multiple units around the valley. They brought something for some purpose, and then they just let it go down. And then when we try to correct it, they just basically say, we don't care. But it's not the big ones that you would read about in the paper or big landlords. They're pretty responsive.
Thank you. And with that answered my second question I was going to ask. So thank you, Madam Chair.
Assemblymember Hardy.
Thank you, Chair. And, you know, I don't think any of us want people living in unsafe and unhealthy housing by any means. So I just had a couple of, just a question on page 7, line 34. What about situations where you may find that, you know, this references that if a tenant has been substantially responsible for causing, you know, damage or some of the conditions. So what about instances where maybe a landlord hasn't been notified, or they have tried maybe, you know, to get things repaired or addressed and they're not allowed to do so? Or if you can, so if you could just maybe touch on how that would be handled differently if you do find in your, you know, your investigation that the landlord has tried and maybe the tenant wasn't cooperative or such.
Venetia Considine for the record. Thank you, Assemblymember Hardy, for the question. I think it's a 2-part question. The first part is if the tenant is substantially responsible for the damage, the tenant, as it says in here, the tenant would not be able to access any relocation. There would be no options for the tenant. If the tenant is causing problems and the landlord is unable to take care of that, I think, again, that goes to the existing legal process for eviction, or they could file a civil case against the tenant to move the tenant if the landlord themselves is having a problem having the tenant move out. So on that sort of lower level one-on-one, that's not what this bill is meant to do. It is meant to do a larger systemic health and safety issues to tenants who are not causing the problem. Does that answer your question?
Committee members, any additional questions? Vice Chair Howdigy.
Thank you, Madam Chair, and I apologize. Thank you for being here and presenting the bill. I apologize if you already went through this, but I walked in late, so I'm going to ask the question. But I walked in as you were going through over the amendments, and just a quick question and concern over the removal of Section 82B2 and 27.2B2 when it comes to the mandating of notices to the tenants who are living in these properties. And so I noticed that we left the mailed-in portion of the notices in both sections 8 and 27, where you're required to mail the notices to each individual residence, but then you removed the posting of the notices on each individual residence. And so I'm curious as to why you submitted the amendment, and you might have already explained it, but I know from working on HOA notices that we've always required them to post in both because people do not check their mail very regularly. I know because I'm one of those people who often have to go to the post office to pick up my mail because it accumulates. And so when it comes to issues like notifying tenants that they may be eligible for benefits of relocation or, or repairs, why limit it to only mail and remove the notice being posted on the dwelling?
Venetia Considine for the record. Thank you, Assemblymember Howdigy, for the question. So this was a request by a couple of the stakeholders that we met with, and we are removing that, but the default for that will be it will require notice and posting, which is the standard practice anyway. I think when this was drafted, it sort of veered from the standard practice, and we just want to go back and make it the standard practice. So there would be all of that, but the stakeholders had an issue with just that piece, so we are going to remove that and put in standard language.
Thank you for the follow-up, Chair. And then so then it's my understanding then that there will still be notices posted. Okay, thank you. Thank you so much, Assemblymember.
Committee members, any additional questions? I don't see any. We will move to hear testimony in support of Assembly Bill 211. Please remember, each person has 2 minutes. We will start here in Carson City. Is there anyone wishing to testify in support? Please remember to state and spell your name.
Chair, members of the committee, Jonathan Norman, Jonathan Norman, the Nevada Coalition of Legal Service Providers. I think the important part of this bill is that this isn't even for bad landlords. This is for so much further than that. This is egregious landlords who are extracting wealth from our community without investing into their property. And it really puts the county, local governments in a place where they could have to rehouse 200 or 400 families. And for an out-of-state, unresponsive landlord to just expect that they can come to Nevada, not put any resources in and extract money is not fair. So I would encourage support because I think this is an important tool for those governments to make sure that our ecosystem functions and that we don't have these really egregious cases. Thank you.
Thank you, Chair, members of the committee. Nicole Rourke, representing the city of Henderson. First, I'd like to thank Assemblymember Considine for including cities in the bill. We made that request because, we're seeing a small portion of what the county is seeing, and so we are here in support of AB 211, which strengthens the existing state habitability requirements, including those under NRS 118A 290, and is fully consistent with the detailed standards set forth in Henderson Municipal Code 15.12. The bill revises the existing law to empower counties and cities to require property owners to repair, rehabilitate, or abate conditions that render a residential property substandard, which reinforces obligations already set out in housing, health, and building codes, and provides another tool to local governments to ensure the safety and well-being of our residents. It also allows for more parties to sue over substandard conditions, which permits not only local government bodies, but also tenant associations, or nonprofit organizations representing tenants to initiate legal actions, and sometimes private actions can be more effective than government actions in these circumstances. This alignment ensures that residential properties in Henderson meet uniform, high-quality criteria for safety, sanitation, and overall habitability. The bill enables more decisive action against properties that fail to maintain safe and habitable conditions. By mandating prompt remediation of conditions that endanger public health and safety, this legislation prioritizes the well-being of our residents and helps complement the city's current ordinances of this topic. By addressing violations before they escalate into serious hazards, the bill contributes to safer neighborhoods across Henderson. And for these reasons, we support AB 211. Thank you.
Thank you, Chair, Committee. My name is Vincent Guthrow. I serve as the Executive Director of the Nevada Association of Counties. We're the statewide organization that represents all 17 Nevada counties. We're, for all the reasons stated, and it gives another toolbox to local government to deal with safety and health of its residents. We support this measure and thank the sponsor for bringing it forward. Thank you.
Thank you. Is there anyone else here in Carson City wishing to testify in support? I don't see anyone. Is there anyone in Las Vegas wishing to testify in support? I don't see anyone. Broadcast, is there anyone on the line?
Thank you, Chair. If you would like to testify in support of AB 211, please press *9 to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Thank you. We will move to testimony in opposition to Assembly Bill 211. Is there anyone here in Carson City?
Good afternoon, Chair, members of the committee. It's great to see all of you. And Commissioner Segerblum, good to see you via video down in Las Vegas. For the record, my name is John Sandy, here today on behalf of the Nevada State Apartment Association. And I appreciate the opportunity to provide some comments on AB 211. The dialogue that's been going on, I think, was really good. Some really good questions about that illustrate some of our concerns about the way the bill is drafted as of right now. We want to ensure that landlords have clear due process protections and reasonable opportunity to correct these violations. I think that is also the bill sponsor's objective, and based on the testimony that we heard. We feel that it is important for cities and communities to explicitly enumerate the process that the landlords will be subject to prior to notice and this bill being implemented. So there's no confusion as to what the procedure would be for a landlord, especially if a landlord were to disagree with the city code's assessment of the property, and just to make sure that there's some ways and mediations that could be worked out before this goes to the drastic remedy of a district court case and also potentially a receiver being appointed over the property, which with a lot of the receiver will have pretty drastic ability to encumber the property, and most likely when the receivership was terminated, there wouldn't be much left for a landlord, especially if those due process procedures were not in place. So with everything, we recognize the intent behind the bill, and we're committed to working with the bill sponsor and this committee to address our concerns through reasonable amendments. We believe that with targeted clarifications and safeguards, AB 211 can achieve the goals without creating undue hardships for responsible landlords. Thank you for your time, and we look forward to working collaboratively on a balanced solution. Thank you.
Is there anyone else wishing to testify in opposition here in Carson City? I don't see anyone. Is there anyone in Las Vegas wishing to testify in opposition to Assembly Bill 211? I don't see anyone. Broadcast, is there anyone on the line?
If you would like to testify in opposition to AB 211, please press *9 to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Thank you. We will move to neutral testimony. Is there anyone here in Carson City wishing to testify in a neutral position to Assembly Bill 211? I don't see anyone. Is there anyone in Las Vegas? I don't see anyone. Broadcast, is there anyone on the line wishing to testify in neutral?
If you would like to testify in neutral to AB 211, please press *9 to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Thank you. Assemblymember Considine, would you like to give any final remarks?
Thank you, Chair Marzola, Venetia Considine for the record. Thank you. This is my first bill this session presenting. I appreciate that I'm in front of the Commerce and Labor Committee doing it. Looking at this bill, I was impressed with the amount of due process in this. A property is a constitutional right. There's got to be due process for this. And this bill only kicks in, or this process would only kick in extreme circumstances, and then even in that extreme circumstances, there is the district court. There are all the steps to go through before that to ensure that, one, a property is rehabilitated properly, that the owner has every ability and opportunity to create a better environment to meet whatever those codes are, and also, three, if it does have to go through a receivership, in the bill, there are requirements for the receivership for monthly reporting and everything along those lines, with the idea for that property to be in good position to go back to the owner when possible. So I really appreciate your time. Thank you.
We appreciate you being here. Thank you. I will now close the hearing on Assembly Bill 211. Thank you, Commissioner, for taking the time to be with us today. One minute recess. Now we're going to come back to order. I will now open the hearing on Assembly Bill 202. This measure revises provisions relating to claims for dental care. Assemblymember Brown-May, you may begin with when you're ready. Please remember to state and spell your name for the record.
Thank you, Chair Marzola, members of the committee. Tracy Brown-May for the record. We are so excited to be here with you today. This is also my first bill presentation this session, so very honored to be in front of this distinguished Committee on Commerce and Labor. My name is Tracy Brown-May. As I previously stated, I'm proud to represent Assembly District 42 in the heart of Las Vegas. And we are very grateful for this opportunity to be before you. We are here to talk about Assembly Bill 202, which revises provisions relating to dental care claims. A little bit of background. Oral health is integral to our overall health. Access to dental services is essential for promoting and maintaining good oral health for all of our Nevadans. I have personally spent a significant amount of time over my lifetime getting to know my personal hygienist, my dentist, my periodontist, my prostodontist, and my oral surgeon. I hope that you have all spent a little bit of time getting to know your oral professional as well. This is not new. Oral health has really become mainstream part of how our healthcare system works, and bad oral hygiene contributes to heart disease and other life-threatening diseases. So it's really important that we have access to good oral health. The Nevada Office of Consumer Health Assistance was established by this legislative body back in 1999. This office helps Nevadans to understand their rights and benefits in their healthcare plans. Then back in 2023, the legislature added an external review process for patients to use in the event of a denied claim for a service or a procedure. While Nevada residents can currently seek a review for a denied medical claim, dental is specifically excluded from this provision. Dental patients currently have no recourse or access to an independent review following the denial of a dental claim. This bill proposes to rectify that issue. Now, I'm pleased to be here today with Paul Klein, who is a principal with Tri-Strategies and a representative for the Nevada Dental Association, who originally brought this issue to my attention. Mr. Klein is here to walk us through the bill summary and will answer technical questions that the committee may have. Chair, with your permission.
You can begin when you're ready.
Thank you, Chair Marzola and Assembly members for having us be here, and thank you to Assembly Member Brown May for sponsoring this much-needed bill. I'm here on behalf of the Nevada Dental Association. We've had a lot of meetings with you all over the years on that and just trying to ensure access to care for dental patients in Nevada. Just in brief, what we're trying to do is change NRS 695G 241 on external review for adverse determination. Here's the bill in brief. Section 1 includes dentists in the definition of clinical peer. Section 2, managed care organizations are not obligated to approve coverage if the decision to deny coverage has already been made by that doctor of dentistry. Section 3 is the most important. This is the intent of the bill ultimately, is it expands the rules for managing complaints and external reviews to include insurance policies that cover dental services. Sections 4 and 5 allows dentists to provide written certifications and requests. Essentially, it allows them to help the patient plead their case for this external review. 6 and 7 allows the independent review organization, the folks doing this external review, to just communicate with that doctor of dentistry, notify them the outcome. Section 8 equates the role of a covered person's treating dentist to that of a treating physician. Essentially, this is already all in place, like Assemblymember Tracy Brown May said, for medical health insurance, that extra look at that case. This is essentially equating doctors of dentistry and dentists with that process. Section 9 ensures that in external reviews, the documentary evidence considered includes recommendations from the insured's dentist, similar to that of physician. Just brief, this is how the process works. After you're denied coverage, and it's that final denial, the patient or the provider could go and use this OCHA, is what it's called, the acronym, to apply for an external review. And at that point, an external review will review the case. This is somebody that is non-biased. This isn't somebody that's on behalf of the insurance dentist or the prescribing dentist themselves. They will look at the case, look at the medical necessity of this case to ensure that the best treatment for that patient is being served. Lastly, just in brief, it adds dental services to the state's already external review process program, ensuring that medical necessity treatments are covered by insurance, putting patients before profits. Any questions?
Thank you. We're happy to stand for questions.
Thank you. Thank you for being here today for your first presentation this session. Committee members, any questions? I don't see any. We will move to testimony in support of Assembly Bill 202. Is there anyone here in Carson City wishing to testify in support? I don't see anyone. Is there anyone in Las Vegas? Broadcast, is there anyone on the line?
If you would like to testify in support of AB 202, please press star 9 to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Thank you. We will move to testimony in opposition. Is there anyone here in Carson City wishing to testify in opposition to Assembly Bill 202? I don't see anyone. Is there anyone in Las Vegas? I don't see anyone in Las Vegas. Broadcast, is there anyone on the line wishing to testify in opposition?
If you would like to testify in opposition to AB 202, please press star 9 to take your place in the queue.
Hi, my name is Dr. Amy Abatan. I'm a general dentist in Reno, Nevada. I apologize to the committee. I tried to raise my hand for the in support section of this. Is it okay for me to comment at this point?
It is. We will move back to support. You may continue. You have 2 minutes.
I apologize for that. So For the record, my name is Dr. Amy Abitian, Abittan. I am a practicing general dentist in Reno, Nevada. I am the vice president of the Nevada Dental Association, and I'd like to speak in favor of this bill, which ultimately is going to serve our patients. So many of our patients are affected by denials to their treatment. And the biggest issue with it is by the time these denials come around, we've already treated the patient and the claims have been sent off, and insurance will come around, they'll deny it for an arbitrary reason, we'll come back, we'll provide documentation for why we did what we did. And they may approve it, but they may also deny it again, and it sets us up for a long battle. But if the ultimate thing is denial, that lands squarely on the patients who have a right to coverage for their medical care from their insurers. And this can be really challenging. When we see a patient for treatment, something is broken. We're fixing a problem. We're fixing something that is likely in pain or likely to get worse, and we need to treat it before it gets worse. We don't want them to get sicker before we fix them. So having these denials come around months after we've already rendered treatment makes it very challenging for us to sit down and say, well, we'd like to justify it as much as humanly possible, but we ultimately don't want this to land on the shoulders of our patients who depend on their insurance to serve them. I'd like to thank the committee for their consideration and Assemblywoman Brown May for taking this up for us. Thank you so much.
Thank you. We will move to opposition testimony. Broadcast, is there anyone on the line wishing to testify in opposition?
If you would like to testify in opposition to AB 202, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Thank you. We will move to neutral testimony. Is there anyone here wishing to testify in neutral to Assembly Bill 202? Welcome. You can begin when you're ready. Please remember to state and spell your name for the record. You have 2 minutes.
Thank you very much, Madam Chair. My name is Helen Foley, Foley, and today I'm representing Delta Dental. In Nevada, Delta Dental serves about 275,000 individuals. Medical insurance is very different from dental insurance. And when you talk about a decision here that people don't agree with when you're talking about a physician, it might be tens of thousands of dollars, which is very dramatic. When you're talking about a dental situation, most of them are in the hundreds of dollars. We have reached out to our grievance and appeals departments and are awaiting some more information from them. But it just seems to me that there are some things that we can do, but it should not be as onerous as this bill, including dentists in every single application that has included the physician. And so with that, I would appreciate being able to come back to you in the next few days with some more information.
Thank you.
Thank you.
Anyone else wishing to testify in neutral? I don't see anyone. Is there anyone in Las Vegas? Broadcast, is there anyone on the line wishing to testify in the neutral position to Assembly Bill 202?
If you would like to testify in neutral for Assembly Bill 202, please press star 9 to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Thank you. Assemblymember Brown May, would you like to give any final remarks?
I just would like to say, Tracy Brown May for the record, thank you so much for this opportunity to present this bill as we start this session. We appreciate your time and attention.
Thank you for being with us today. I will now close the hearing on Assembly Bill 202. I will now open the hearing on Assembly Bill 198. This measure revises provisions relating to certain inflatable devices. We once again have Assemblymember Brown May with us. When everyone's ready, please begin.
Good afternoon, Chair. Once again, Tracy Brown May. For the record, I'm happy to represent Assembly District 42. We are excited to be before you today. I have with me today Mitch and Wendy Hammond, who will be here to tell their story as we progress through this bill presentation, and Elliot Mallon, founder and president of Alpine Strategies. Together, we will present this issue about inflatable devices. So Assembly Bill 198 is here for your consideration. This bill sets forth requirements and restrictions concerning inflatable devices, which include constant air inflatable bounce houses, inflatable water slides, similar devices. Many of us are familiar with these devices as we've seen them as many backyard family events and activities, picnics, church picnics, social events. So as background, inflatable bounce houses and inflatable water slides are also known as inflatable devices. As I've just stated, they are fixtures at outdoor events. My church community often hosts events with outdoor activities, bounce houses, as part of our community events. They're available for purchase in the public. Hundreds of companies in the United States provide commercial rental options. With daily rental costs in the United States as low as $100, bounce houses are an affordable activity for many families, and it's a great way to organize entertainment for large numbers of children who jump up and down inside of a bounce house. That's what we're talking about. While they are a source of fun and a general feature at these wonderful events, they also pose some known safety hazards and cause many injuries. Many people are not aware of that. I have stood post at one of my own bounce houses at a church picnic to make sure kids didn't get trampled, right? So it's a thing that happens. The U.S. Consumer Product Safety Commission found that there were an estimated 113,272 emergency department treated injuries associated with inflatable amusements from 2003 to 2013, so over a 10-year span. 90% of those were due to bounce houses. That's a lot of injuries for our kids. A much smaller subset of injuries occurs with the weather as a contributing factor. These devices are safety hazards when dragged, blown, lofted by winds we've all experienced here locally as in the recent weeks. A recent study by the University of Texas at El Paso noted that there were 132 documented cases of wind-related bounce house incidents from January 2000 through December of 2021. The 132 incidents caused at least 479 injuries, and in addition, 28 fatalities. 28 kids lost their lives. In the last year alone, we have 3 reported deaths from bounce houses. That's kids dying in bounce houses. They're supposed to be fun. Due to the nature of the construction of a bounce house and their high aspect ratios, they can be tipped over, rolled along the ground, or even lofted into the air by strong winds or gusts. Even when occupied, children can be injured or killed while inside an air-transported bounce house or by falling out of wind-blown bounce houses. I wish this was a distant and tragic story. It is not. The one we're simply sharing with you today is a true life story lived right here in Nevada. Chair, with your permission, I'd like to introduce Mitch and Wendy Hammond. They're here to share their story about their daughter, Lizzie. We are wearing our Lizzie pins today, and this is the reason that we've prompted this bill. So if you don't mind, I'll turn it over to the Hammonds.
Wendy Hammond, WendyHammond. I'm Lizzie's mom. This is my husband, Mitch Hammond, MITCH Hammond. They've asked us to testify on behalf of this law. It's been 6 years in the making for us. So I do appreciate your time. and letting us share our story. So one of those kind of buried down, it's hard for us to share, but we feel it's very important for you to hear and to know how to protect our kids.
Take your time. You don't have to rush.
Thank you. So we do want to say thank you to all of you for listening. Thank you to Assembly Tracy Brown May and Elliot for getting us to this day, and all of our supporters here. Our children are here as well, Abby and Danny Hammond, and Grandma and Grandpa Lynn Scott. So we've got a lot of support here for Lizzie. They asked us to share our family story. So Mitch and I were married in 2008. Our kids are Lizzie. She was born in 2009. Danny was born in 2014. And Abby was born in 2016. So we forgot to send Elliot pictures of our family, but we'll share those as we leave. This is us at a wedding in June of 2019. To our story of July 14th of 2019, Mitch was in Virginia at a military training. He was scheduled to deploy to Poland that year. We had been invited to a birthday party. So what do you do on a sunny afternoon in July but go to a party with a bounce house and a water slide, and just to a birthday party? We actually did not know there'd be a bounce house there till we got there. We already had a family rule that the kids couldn't get in a bounce house because we already had a friend who'd snapped a leg inside one. So when we pulled up, the kids saw the bounce house and they're like, oh, it's got a bounce house. Are we gonna be able to play? I was like, well, let's see how the day goes. If it's not too crowded, you know, that's our main concern, is too many kids inside. That's how kids get injured. It's a mosh pit. Not really giving too much thought to the wind. I did have a premonition. I was like, oh, I better make sure it's staked out or weighted down, you know, just that mom check on things. So I visually looked down at the bounce house and it had stakes around it. And I was like, oh, it's staked out. Not realizing those stakes are actually just intended to hold it from shifting. When the kids are bouncing, the bounce house kind of walks. So I didn't know that. So I was falsely reassured that it was staked out. Again, we're enjoying the party. I was out there on the patio the whole time watching the kids. There was a water slide. Abby and Lizzie were playing in a bucket of water next to the water slide. The party started to wind down. So I had just looked at Lizzie as she got out of the water from Abby and was walking towards the bounce house. And she looked at me and I said, hey, you got 5 minutes. She gave her, okay, and was going towards the bounce house. Well, Danny and the birthday boy and another boy were going into the bounce house, opening a gift, running back up to the patio, grabbing a gift, going back in, opening it. So they weren't in it the whole time. They were going to and from. So on one of these trips in, Lizzie was now in there. So there were 4 kids in the bounce house as a gust of wind, huge force of wind, whatever way you want to describe it. It wasn't a whirly gig, I can tell you that for sure. The wind started to move the bounce house. I was closest to Abby, she's 2 at the time, in a bucket of water as things are starting to fly. Lizzie was with Danny, so I was like, well, at least I've got Lizzie and Danny there. And all the parents were running towards the bounce house because that's what was lifting first. So I'm going for the baby, and then the water slide picks up as I see the bounce house pick up. The bounce house goes up into the power lines, and I guess that's a lucky thing that it hit the power lines because it could have kept going. But it hits the power lines, it goes along, and you see a big arc of electricity, and it's hanging there. And so I had gone to get Abby while this is happening, and as I see the bounce house go this way, I then get completely knocked down, things kind of go black for a second, and I kind of open up my eyes to facing a different direction. I'd been knocked over by the huge inflatable water slide. That also took flight. So in this picture, you have the bounce house is here. If you look closely, this is in your file, you can actually see Lizzie's body. And then below, this is the water slide. That's how far everything took flight. I don't have the measurements. I would assume that's in the police report. I'm a girl, I don't know footage. But it hung in those power lines. While we were trying to reach him, we called 911. The fire trucks show up. They had to wait for another fire truck to show up with a bigger ladder. So you're standing there looking at your kid hanging with no way to help. There's 3 kids in the bounce house at this time, because as it lifted, one kid had fallen out. So if it had weights they would have had time, I believe, to get out. There was one who was out, I mean, he fell, but he was able to get out. If they had more time, they probably could have all gotten out, or we could have helped them more, or the parents could have held. Something could have helped. So they're hanging there. We wait for the second ladder truck to get there. Well, now we have to wait for Nevada Energy to get there, because we had to wait for Nevada Energy to come and turn the power off. That poor man, as far as I understand, he was hauling butt from Spanish Springs to South Reno. According to some records, it's about 10 to 15 minutes that the kids hung there. Again, 3 kids in the bounce house. The firefighters get the ladder up, start to take out the birthday boy first. He was the only kid we could hear from the ground. He was at the window was there. He had got his face to the window and could yell back at his mom that he was okay. The whole time I could not see or hear Danny or Lizzie. We got the birthday boy out first. Danny came out just looking terrified. And then they were trying to get Lizzie out, and the guy was kind of struggling. And I was like, she's really big, actually. Like, for her age, she's all muscle. Like, she's a really strong kid. So he was able to get her out. And as soon as she came out, you could tell she wasn't okay. Got her to the hospital. They restarted her heart. Meanwhile, trying to get a hold of Mitch, get him home through first Red Cross back here to Reno from Virginia. So he arrived on Monday. Lizzie was then declared brain dead on Tuesday. They do a really great test. Don't recommend watching that with your child ever. And then we made the choice to do organ donation. So she was an organ donor. Her kidneys went to 2 kids out of Northern California, and her liver went to a little boy who's number 2 on the wait list out of Texas. So it actually helped a little boy across the nation. 2 months later in September, while we were driving to a funeral for a soldier, is when I got the call from the ME, and Lizzie was, what killed her was her C1 went into her brainstem. So at some point, we all don't know what happened in the bounce house. I'm here to talk to you also about the current implications. So it's not just about Lizzie dying, it's about all the trauma to the rest of us. With our son, he's been diagnosed with PTSD now. He has an abnormal fear of death for a 10-year-old, as per a doctor. It's not me saying it. He fears like that his cat will die. When this all first happened, he and Abby were terrified of the winds. If we were leaving the hospital to come home, they would scream as you try to get him out of the car into the house. They were taking him to the movies, trying to entertain them. They would freak out at the mall because of the wind. And then Danny still has a very severe fear of heights. You can't get him up on a ladder. You know, we try. He's just very fearful of it. He also thought he had killed his sister because he was standing on her to try to get to the window. We try to resolve that, but again, this is trauma to the brain that I can't heal, that we're trying to heal. Obviously, our family trauma is losing a child, right? Deal with lots of anxiety and panic attacks. I do kind of laugh when people complain that they can't sleep because of the wind. I'm like, well, yeah, I have no idea what you're talking about, but okay. We also have obviously a lot of trauma to the friends and family that are related. You know, I can't imagine being another parent trying to explain to your 9-year-old why their friend Lizzie was killed in a bounce house. It's pretty unexplainable and unable to be understood by children. We affected lots of nurses at the hospital. It was the biggest honor walk they'd had because Lizzie was such a huge impact in the community. This was a kid who, if you asked her, hey, do you want to go feed the homeless this afternoon? She'd be like, yeah, when do we go? There was never like, oh, I'm sorry, I've got to finish my iPad, or no thanks, it's scary. She was first to action on anything you needed help with. We found out at the memorial service she'd helped kids with bullying. She's inspired nurses to continue on and do more work. So our time at Renown has benefited a lot. They're giving me the moments of like, I don't want to overstay my welcome. We are asking for this law, and we've been advocating for it because there's a need for education for our public. If I had known that those were just ones to keep it in place, I know Reno gets windy. I would have asked, you know, where's the weights? I was not the one who signed the contract with the bounce house operator. I don't know if he advised her. He did not have a business license, and he's faced no charges because there was no law that he broke. He'd taken the labels off of the bounce house, so we couldn't prove he set it up wrong. There's nothing for us to stand on with him. He did not have insurance. He had nothing but money, cash flow, from when he rented out these bounce houses with children in it. I do believe if he had weights on it, it would have made a big difference in our world. Just some common sense things. Leaving the manufacturer tags on would have helped. And just trying to protect our kids is what we're here for. We do have a lot of kids in your lobby. I know this is weird and different, but we do believe kids are important. They're our future, and we need to keep them safe. And they're here because their sister Lizzie cannot be here. So that is why they're here. I know they're a little bit of a pest, but that is our future, and we need to keep them safe. So thank you again for your time, and we appreciate this opportunity.
Thank you for sharing your story and your vulnerability. Chair, if it please you, at this time, we'd like to go into the bill. Mr. Malin will walk us through the bill language.
Chairman Arzola, members of the committee, Elliot Malin for the record, ELLIOT MALIN, here representing the Lizzie Hammond Foundation. Thank you for the opportunity to present this bill, what we are affectionately calling Lizzie's Law. I will be presenting the sections of the bill and look forward to the conversation. First, I want to say that I'm thankful for the Hammond family, for their willingness to be here today and tell their story. I'm thankful for Assemblymember Brown May for picking up the phone when I called to chat about this and agreeing to carry it. I also want to thank those in the inflatable device industry who I know are here today. We've worked diligently with them to try to find compromise to keep kids safe, and I think we have gotten a long way in accepting a lot of the amendments that they brought forth, because I think that we want to make sure that we're keeping the good actors there and helping them. So to get us started, Section 3 of the bill defines inflatable device as one that is air-filled with the incorporation of a structural and mechanical system that employs a high-strength fabric or film that achieves strength, shape, and stability by tensioning from internal air pressure that can be used by a person to bounce, play, slide, climb, or interact for recreation purposes. These include, without limitation, a constant air inflatable bounce house, inflatable slide or water slide, obstacle course, pool, or enclosed inflatable trampoline. Section 4 of the bill defines an operator as a person who is on site at the location where an inflatable device is used, who sets up, operates, maintains, or supervises the use of an inflatable device. Section 5, the bill defines an operator business as a business that is engaged in making inflatable devices available for use in the state and employs, controls, or directs, or hires an independent contractor to operate an inflatable device on the business's behalf. Section 6 of the bill requires that a business shall not engage in making inflatable devices available unless they hold a valid state business license and liability insurance or certificate of insurance bond of a surety company or any other surety of not less than $1 million. Section 7 requires an operator of the business to keep a logbook for any inflatable device which is available for the use by the operator business, that the logbook may be written or digital and must be available for inspection. It requires that an operator must record the results of each inspection conducted pursuant to sections 8 to 11 of this bill in the logbook, and requires that if an inflatable device is either temporarily or permanently discontinued for use at an event, that the time and date be recorded for any reason described in sections 8 to 11 of this bill, or any reason that is defined in the manufacturer's manual for the device. Section 8 of the bill requires that an operator, before allowing anyone to use the inflatable device, inspect the inflatable device and the location where the device is to be used in accordance with sections 9 through 11, and that the use and setup conforms to the manufacturer's manual for the device. Further, it requires the operator not allow any person to use the inflatable device if the inspection reveals a hazard or potential hazard that would make the use of the device unsafe. Section 9 of the bill requires that an operator inspect the inflatable device to ensure that all manufacturer's labels remain attached to the device and are legible. If any label attached by the manufacturer to the device is missing, the use of the inflatable device must be discontinued, and that inflatable device must be destroyed. Further, this section prohibits the transfer or sale of an inflatable device that does not have all of the original manufacturer's labels still attached. Section 10 of the bill requires that an operator shall not permit the use of an inflatable device if the wind speed exceeds 20 miles an hour, which it says 10 in the bill. I'm going to go through conceptual amendments as well. We increased this from 10 miles an hour after negotiating with the inflatable device industry and acquiescing to their ask of 20 miles an hour. An operator must use an anemometer to calculate wind speed at the time of setup and record that in the logbook. In section 10.3, we are accepting an amendment on the language to not require that the operator remain on the premises, but instead instruct the renter, the customer, on how to test for wind speed to ensure safety of the users, and if the wind speed exceeds 20 miles an hour, that the device be deflated and made unusable for children. Section 11 of the bill. After negotiating with the inflatable device rental industry, we are instead proposing that weights be used at all times and in striking weights and stakes. The purpose of this is that we learned that 40% of inflatable devices are installed for use on solid surfaces, such as parking lots. And using stakes is unrealistic. We don't want to force them to drill into a parking lot. However, we do believe that weights are paramount, and we are reducing it from 100 pounds to 75 pounds to conform to industry standards. Section 12 of the bill requires an operator's warning sign that is in red and not less than 72-point boldface type. And then section 13 of the bill stipulates that the purpose of any civil action involving an injury to a user of an inflatable device made available for use by an operator business, that any violation of the provisions of this act would create a conclusive presumption that the operator or operator business was negligent per se. And then with your permission, Chair, I'm going to just briefly go through the conceptual amendments. So the first conceptual amendment, because we are here due to Lizzie, we would like to add in a preamble about her, a little bit about her. Two, there's a fiscal note on the bill currently. For local government, it says increases or newly provides for term of imprisonment. We don't actually have any criminal penalties in the bill, so we would like to strike the fiscal note. Three, we have agreed on no staff, but require instructing rentee how to take wind speeds and break down the inflatable device if wind speeds exceed statutory limit. Four, change the wind speed from 10 miles an hour to 20 miles an hour. 5, change weight minimum from 100 pounds to 75 pounds. 6, change language to require weights at all times and no stakes. 7, include language and warning sign that says the inflatable devices have caused injury and death if installed incorrectly. 8, logbook must only be kept for 2 years. 9, logbook inspection of records is for the customers, users, local and state agencies only. 10, we're going to extend the effective date to January 1, 2026 to allow compliance for businesses. 11, change section 3.2 to read outdoor recreation, because we are really talking about outdoor recreation. And then in 12, we have various points of just conforming language for section 8.1, 8, 9, 12, and 13. And with that, Chair, I am happy to take any questions. Thank you.
Thank you, Chair. As you can see, we've done, and committee members, we've done a fair bit of work to make sure that we are focused on the safety and well-being of our families and our children. The current regulations that we are proposing are in existence in Clark County, Nevada currently. We are just hoping to make it a statewide regulation that we know has been in practice for a period of time. We want to continue to support bounce house operators. We believe that they are a part of our entertainment industry, so we certainly don't want to disparage them, but we do also want to make sure that they're being operated effectively with the care and safety of our youth in mind. With that, we'll stand for questions.
Thank you. Before I go to committee members for questions, I just want to say my heart goes out to you and your family. I can't even imagine what you guys have been through, and you're right, it is our responsibility to protect all children. And so thank you for being here and sharing your story, even though I know it's really hard, but it's much appreciated. And with that, I will start with questions. Assemblymember Miller.
Thank you so much, and I echo the chair. Obviously, our hearts go out to all of you, the immediate family, parents, siblings, friends, family, the entire community that lost Lizzie. With that, my question is, Section 10.3, the part that was amended out, the part that, one of the things that I felt was really effective about the bill was, and maybe I should back up to everyone's experience. We all go to these parties, it's in the backyard, and even oftentimes the homeowner, the adults are partying or on the other side of the yard doing their things. Kids are just running on the loose, and of course, stuff happens. So with this, it implied originally that the operator, the business operator, would be there the entire time supervising. I understand that that part's been amended out and that now the renter or homeowner would then be required and taught how to measure the winds and such. My question is at this point, so the business owner has done their job. They have taught the homeowner or the person or entity renting how to measure, what to do, what the expectations are. What then happens if that person renting the bounce house or whatever doesn't comply, doesn't follow through with those requirements?
Elliot Mallon for the record. May I go direct?
You can go direct.
Thank you. Thank you for the question, and I really appreciate it. This was a big point of contention. Personally, I would love to see that there would be an operator there the entire time. I also understand that it's unrealistic to these businesses, the cost to it. In some of the conversations I've had, what I've learned is that these operator businesses are requiring certain things in their contracts, and they are already doing a lot of this. And so I'm going to have to defer to a lot of what these contracts say. We're also, just to point out to another thing on this, because I didn't talk about enforcement about this, is that we're also working with local governments to try to ensure the enforcement of this in compliance. It's a tricky situation we have. We want to have these operators there the entire time. The operator businesses can't necessarily afford to have them there the entire time. So we're trying to find some common ground. And we believe that within these contracts and with the insurance requirements and everything, that if we can require that they at least train and instruct these rentees on how to do this, that we can save some lives.
Chair, may I have a quick follow-up? Thank you. So with that, and it's in the contract, then if something happens, that now the liability would be on the renter, correct?
Elliot Mallon for the record, potentially, depending on what the contract says. I can't say with what's in front of me because I don't have those in front of me. But there's potential for that, yes.
Thank you so much.
Thank you.
If I may, Chair, Assemblywoman Miller, the intention is to start to put in regulation currently where none exists. The operator in Lizzie's incident did not have a business license, was not regulated, did not have liability insurance, and did not educate the people that were at the bounce house, right? So this piece of legislation gets us incrementally to make sure that our business operators are licensed, they are insured, and then they are training the people that are renting the devices to operate them appropriately. In my experience, responsible business owners who operate these bounce houses are following up with regard to what wind speed is while their business is in operation, whether they're on site or not.
Thank you so much. Thank you, Chair.
Thank you. Next, we'll go to Assemblymember Monroe Moreno.
Thank you, Madam Chair. And for the family, I feel for you. I'm so sorry for your loss and for the pain that your family is still going through. It will take years, and we have a responsibility to help us make this safe for all families in the future. Thank you for sharing your story. I can't imagine being in your shoes. Mr. Allen, you had said when you were presenting that a large number of these inflatable devices are put on hard surfaces. But I too am a mom and a grandma and host a number of community events, and they're generally in parks where there are soft surfaces. Is there a way that in the bill to amend the language that if it isn't a soft surface, to have both stakes and the weights when the surface can do both as an added measure?
Elliot Mallon for the record, absolutely.
And then the training of the parent. I know when putting a birthday party together or a community event together, it's hectic in any event planning. How much training would that event host have to have? And is there a way, I know I've rented before, and I've rented from licensed inflatable houses, and they've instructed us how to use it. And we've been very responsible and assigned people to be there for that instruction, so we have multiple people who know how to use it. But what is that training amount? And businesses that I've used before have called in to check on us like an hour or 2 hours later to see how things are going. Is that something that could be added in as well?
Elliot Mallon for the record. I think that's easy to add in. When addressing the training requirement, so I recently learned what an anemometer is because of this bill. I didn't know that. But it's not a very expensive device to be able to test wind speed. And then training them on how to deflate this device and make it inoperable. I actually don't think that would take much time to train an individual. It's one thing to test the wind speed and then basically take down the inflatable device.
Thank you, Chair.
Committee members, any additional questions? Assembly Member Torres Fawcett.
Thank you, Assemblymember, and thank you so much for the presentation and being willing to join us as a family to share your story and to talk a little bit about Lizzie. So I had a question that's specific to the enforcement agency. I noticed in section 7 of the bill on page 3, it talks about the logbook and that logbook should be ready to inspect. But I just wanted some clarity on what enforcement agency would be checking that logbook, whether or not we're expecting like the health district, or if we would expect local governments or law enforcement to be responsible for that. And then I wanted to kind of better understand it a little bit, is that it seemed, the way I read it, that the logbook would be staying with that device. I just wonder if that's even realistic. If I was a company and I had I left my bounce house there, I would not want to leave my logbook with a family that I do not know. So I just want to get some clarity on that.
Elliot Mallon for the record. Again, thank you for the question. I'm going to try to take those in order. So can you remind me of the first question, because I'm currently on the logbook?
Yes, enforcement agency.
Okay, sorry, thank you. Again, Elliot Mallon for the record. We are working with local government to try to figure out what that mechanism looks like for them. From what we heard, they were fairly supportive of this and just want the ability to enforce. And so we will have an additional conceptual on that. When it comes to the logbook, personally, I don't think that's overburdensome. If I were them, I would have multiple copies, especially if it's digital. But I think, and part of it is also who can inspect the logbook. It's going to be the customer, basically the user, the guardian of the child inside the device, and enforcement agencies. I don't think it's too much to ask to keep it there so that way parents and guardians can understand what this device has been through.
If I may follow up on that, Assemblywoman, there is, first, we've spoken with Clark County. Business licensing would be the primary.
Assemblymember, can you state your name,
I apologize.
please?
Assemblywoman Tracy Brown May for the record. Clark County, currently business license, is the division that would oversee to ensure that they are operating as a business license, right? So that would be the entity to make sure that it is an appropriate licensed business. The logbook, often on the side of a bounce house, is a polyurethane sleeve where there are necessary declarations included. And so it would not be uncommon to find a logbook or additional documentation identifying that specific bounce house, and its compliance with the expectation would be attached to the side of the bounce house.
Thank you. And just a quick follow-up, if I may, Chair. I think I would like, and I don't have to have all the answers right now, some more clarity on on that part of the legislation. But additionally, I do think that local government should kind of take a role there. But I think that needs to be clarified in this piece of legislation, that local governments need to determine what that logbook process looks like. Thank you.
Assemblymember Cole.
Thank you very much. My sister actually got a kidney transplant last year, so I appreciate that part of your story as well. Just a quick question on whether or not we could require the contracts to include adult supervision to be there, because obviously a 16-year-old kid isn't going to be able to realize what's happening in the weather. And then my other question is on the liability insurance. Is the homeowner named as an additional insured on that policy to protect their interest?
Assemblywoman Tracy Brown May for the record. Thank you very much for the question. We're certainly happy to look at both of those recommendations for clarity going forward as we finalize what that amendment will look like. Both are very reasonable. We appreciate your comment. Thank you.
Committee members, any additional questions? Assemblymember Hardy.
Thank you, Chair. And I too just want to express my condolences to you and for being willing to be here and share your story. I have daughters and have been in bounce houses, and it's just tragic what happened to you. But hopefully, you know, through this law, other children will be protected, and Lizzie will be, you know, for her name will be used in a good way, this experience. So I just wanted to talk about in the bill in section 12, there's parts in here where it says the device has to have the warning labels attached to it that come with the device, the manufacturer's warning labels. And then you also have mentioned a sign that has to be in addition to that. So if you could just go over what's required on the sign in addition to the warning labels.
Elliot Mellon for the record. So on the devices come warning labels. Part of what we want to do is make sure that they can't be ripped off. I know and I'm sure all of you growing up saw the little tags on your mattresses and were afraid that you were going to be sent to jail if you ripped them off. We're talking about effectively the same kind of tag. We want to keep them on there because it's the manufacturer's warning. We want to see additional language. I kind of glossed over it because I was trying to respect your guys' time a little bit. But let us go, that is this one. So the operator's warning sign in red and not less than 72-point boldface type. The sign must not be less than 2 feet in length and in width and must contain the following information, a type and font that is easy to read and is substantially the following form. 1, a logbook of safety inspections for this inflatable device is available for review upon the request of any person. 2, the maximum wind speed for the safe operation of inflatable device in our state is 20 miles an hour is what we're determining. The operator is required to use and keep available for use an anemometer to monitor wind speed before and at all times during the use of this device. If the wind speed exceeds 20 miles an hour, the operator is required to discontinue use of the device. 3, this inflatable device must be anchored to the ground during use. To each point where the device is anchored to the ground, the operator must use 75-pound weights at each anchor point or more if the manufacturer requires, and if with Assemblymember Monroe Moreno's comment on soft surfaces stakes. 4, the maximum number of users for the inflatable device is determined by the recommendations of the manufacturer according to the warning labels attached to the device. And 5 is that a device installed incorrectly can lead to severe injury and or death. Thank you.
Committee members, any additional questions? I don't see any. I do have a question on... It relates to the wind speed. I see that you're changing that from 10 miles an hour to 20, and I just wanted to ask why and what the thought process was behind that.
Thank you, Chair Marzola. Elliot Mellon for the record. Sorry. This is the first hearing of the session. I'll get it. So we started at 10. What we know is that 0 to 10 miles an hour, 33% of incidents occur. We were talking to the bounce house operators in our state when they reached out to us, and I'm very grateful for their feedback, that we believe that these devices can be safely used and reduce incidents at 20 miles an hour. I know that there is a request to go up to 25 miles an hour, and to be very clear, 51% of all incidents occur between 0 and 25 miles an hour. That 5 mile an hour difference is the difference point of 18%. In my mind, that's not necessarily worth it. And so we were able to keep this low at 33%. And if installed correctly, hopefully we can have 0 incidents.
I might have misunderstood you. Did you say from 0 to 10 miles an hour, 33% incident happens?
Sorry, Elliot Mallon for the record, 0 to 20 miles an hour is 33%. Thank you.
Thank you. I have a question for Mr. and Mrs. Hammond. Was it windy initially? And then all of a sudden it just became windy?
Wendy Hammond. It was not windy. It was a very calm day. I think the party started at like 11 or something. And again, we are always kind of the last to leave. You know, Mitch was gone, so the kids were enjoying their time. And I was visiting with the mom. And to go on to, like you're saying, sometimes kids are left unsupervised. I actually sat on that patio the whole time, keeping an eye on all three kids. It's 1 on 3 when dad's deployed or active duty. So if I went to the bathroom, again, Abby was 2 at the time, so I'm not leaving them unsupervised for a minute. So no, the wind was not high. It had just started that like gentle afternoon breeze where not even a breeze, but like when you're wet, the kids weren't on the water slide anymore. It started to get a little chilly for that. But it wasn't where we were looking at each other saying, oh, gee, it's getting windy, let's take this down now. There was no comments about that. I was sitting with the homeowner, birthday mom. There was never like, oh, the guy said I should take it down, nothing. And then that gale force or whatever it is that came through, again, it was not like a whirligig. Like we know those around Nevada, there's nothing you can do. It was this huge gust came through. And while I have you, we wanted to make sure it's reported that Lizzie's accident happened at 17 miles per hour. So for us to move to 20, it hurts our hearts. I'm hoping it doesn't hurt any kids, because that is why we're here. That's why we share our testimony, is to help others. I don't purposely put myself through this pain. I'm not sadistic that way. I am here to help others. Our family is a family of service. That's what Mitch does with the military. That's what we do with all of our community service. It's to help others and prevent safety as best as we can. And I do believe, adding in, while I have the time, sorry, hate me later, the sign is gonna help, because the sign is gonna be when a professional installer puts up that bounce house. But these parents are gonna see that sign, and when they're over at a friend's house and they have a bounce house set up that they bought off of eBay or Craigslist from a person in the back of 7-Eleven, I've heard, you're gonna have that thought as a parent of, wait a minute, when I was at the other place, it said it should be weighted down. Where's your weights, friend? Where's your weights, parent? It's gonna help advocate through the community and keep our kids safe just in that community reach and public education. So thank you for listening. We wanted to make sure we got this wind speed in there for you, that we are flexing with these bounce house operators. I know that the one we were dealing with obviously was a bad operator, or whatever you guys call him. But it still took a child's life, and so we're trying to educate the public and provide teeth for other parents. If something like this happens, that they have a leg to stand on. We were left with nothing. There was no law. The guy had no insurance. He was a bad actor, as you say. So thank you, and I thank your guys' time and for listening.
Thank you for answering my question, and you actually answered my second question, the wind speed at the time of the incident. And the reason why I asked you if it had been windy, because to me, if it wasn't windy and then all of a sudden there's a gust of wind at 10 miles an hour, right, that's still significant. And so I was just trying to understand why the change to 20 miles an hour. So thank you. We will go to Speaker Yeager.
Thank you for the time, Madam Chair, and thank you for being here and sharing. Thank you for everyone who's in attendance today. I know there's a lot you could be doing today, and we just appreciate you being here. I just wanted to follow up on this line of questioning, because when I heard 20 miles an hour or 25 miles an hour, of course, I looked at the sheet here, and it talks about 17 miles per hour that happened in this incident. So, you know, my question, and maybe it's not something that can be answered today, but I think what you're probably going to say, Mr. Mallon, is that, you know, if this was properly weighted down, maybe it wouldn't have been an issue at 17 miles an hour or 20 miles an hour. But is there data or safety guidelines around that question of if something is properly secured, whether it's by stakes or whether it's by weight, what the wind tolerance would be? Because I just want to make sure we're making this decision based on data. I think in the situation we're hearing here, 10 miles an hour might have done it, because it seems like it wasn't properly secured at all. But just want to make sure we have a good data and underpinning to make that decision as a committee.
Thank you, Mr. Speaker. Elliot Mallon for the record. So there is information out there. The top recommended speed is 25 miles an hour. That is the top recommended speed that we can find. I know it says to tell you what the acronym means. I don't know what the acronym means. I'll get you that information. But the ASTM guidelines would say that. But it's also the ASTM guidelines that we use to determine that 18% jump from 20 to 25 miles an hour, and why for us it's painful to get there. And I can get you more information. Thank you.
Assembly Member Monroe Moreno.
Thank you, Madam Chair. You know, as I sit here, I get to use the Google machine. And as you look at it and you go to Bounce Horizon with the Bounce House Rules and Regulations Complete Safety Guide for 2024, and you go down to the Essential Bounce House Safety Rules, just a quick reference guide. It goes through the age and the weight of children. The maximum weight, 75 pounds. No one under 6 years old. Adult supervision for 4 to 6 kids. But when you go to the wind, it says wind speed should be below 15 miles per hour, not to use during rain, and temperatures below 90 Fahrenheit is recommended. The family shared that the wind speed was at 17 miles an hour, and we heard the tragedy that happened at 17 miles. Moving it to 20 would be problematic for me. I just feel that we risk losing other children at 20 miles an hour. Could a happy medium be the 15 miles an hour?
Tracy Brown May for the record. Assemblywoman Monroe Moreno, first I want to thank you for your love and care for our youth. And I would absolutely say we are more than happy to amend the language back down to 15 miles an hour, which was our original recommendation. As we continue to negotiate to get support relative to this bill, we have considered others. Given the feedback from this committee, we are more than happy to go to 15 miles an hour, which was our original recommendation, and I thank you for that.
Thank you, Chair, for the second round of questions.
Committee members, any final questions? I don't believe so. So we will move to testimony in support of Assembly Bill 198. Is there anyone here in Carson City wishing to testify in support? You may start when you're ready. Please remember to state and spell your name for the record.
Thank you, Chair Marzola. My name is Justin Randall, and Justin, Justin, Randall, Randall. I'm here today speaking on behalf of the Nevada Justice Association. I am a practicing personal injury attorney in Las Vegas and a member of the NJA Board of Governors. We support this basic consumer protection and safety measure. As you've heard today, this is an industry rife with injuries to innocent children and citizens in our state. The current lack of regulation in this area creates unnecessary tragedies that could be avoided with the most basic and proper safety protocols. This bill simply promotes personal responsibility for anyone who causes harm to another individual. Often, the reputable and responsible inflatable companies are already providing these safety measures. We support requiring and expanding this accountability for the entire inflatable industry. This bill simply promotes safety and accountability for all bad inflatable actors in our state, and we express support of this important bill. As Mrs. Hammond stated, children are our future, and this law is necessary to protect their future in our state. Thank you for your time.
Thank you. You may begin when you're ready.
Thank you very much. Good afternoon, Chair Marzola and members of this committee. My name is Catherine Nielsen, and I'm testifying today on my own behalf and behalf of my family. First, I want to thank you for your time. My husband had the honor of serving in the Nevada Army National Guard with Mitch Hammond Jr., which is the son of Mr. Senior over here, Lizzie's brother. I firsthand witnessed the grief that this family experienced. I watched Lizzie's honor walk at Renown, and the pain is something that won't ever go away for them or any of the other 28 families that lost someone. Our family personally no longer allows bounce houses at any of our birthday parties, and don't let our kids go on them either. And I don't know any of you guys, but birthday parties are really meant to be joyous occasions full of happy memories. It's our responsibility as adults to keep these children safe. We've made the changes for our families but we're counting on you to help the rest. And I urge you to pass this measure. Thank you.
Good afternoon. My name is Robert Quirk, RobertQuirk. I'm familiar with the Hammonds. They provide some professional services to our company. I'm the owner of Lincoln Heating and Air Conditioning. By the way, I own many anemometers, and the acronym ASTM is a American Register of Standards and Measurements. It is information that engineers regularly follow. It has everything to do with stresses and measurements. It's a long list, but I won't go on. As a contractor, a specialty contractor, I am commissioned, particularly in my field, as a literal guardian of public safety. As I was sitting waiting for my opportunity, I counted that there are 9 licenses or certifications that I have to maintain in order to administer our contribution in the marketplace. Even in our orderly society, there are many dangers which are constantly present. Many of them, most of them are invisible, particularly in this case, and I name as examples: flammable gases, electricity, venting, combustion gases, and airflow, all of which I deal with on a daily basis inside of our company. All of these forces can, and under some circumstances, are dangerous and even lethal. I have many licenses, and I sometimes feel very put upon by all of the licenses and all the inspectors and all of the insurers that are constantly monitoring our behavior.
Sir, if you can finalize your comments, please. You're at 2 minutes.
I'm sorry.
That's okay.
I'll conclude. When I find that there are elements of society that are unregulated, I maintain that that is where the dangers exist, and that is the condition which exists here. Thank you.
I'm Roger Linscott. I'm the grandfather of Lizzie. We were called to the scene over there where the bounce house was in the power lines. So this is a personal thing. We were kept on the perimeter of the scene there for, it seemed like an hour before we were allowed by law enforcement there to take custody of the kids that didn't go to the hospital. I was surprised to learn that there were no charges of negligence or any relation to a homicide that occurred as a result of this bounce house being misapplied on the site. I don't know whether the operator even received a citation for not having a business license. We were treated like stepchildren there. We weren't allowed to have the kids for an hour. They let the welfare people come in through the police lines to interview the children. We weren't even allowed to be on hand while they did that. The sergeant in charge called it a crime scene, but nobody was charged with the crime, and we weren't allowed to go in. So those are basically my points. The law enforcement really should be able to step forward on these things and take some sort of action, especially when something as freakish as this happens. Somebody was responsible, but nobody was held responsible. Thank you.
Thank you for being with us today.
I'm Roxanne Riley, R-I-L-E-Y. I'm great friends with Mitch and Wendy Hammond, and this needs to go forward so we can have people held accountable.
Good afternoon, Kim McNamara, K-I-M-M-C-N-A-M-A-R-A. My friendship with the Hammond family began in the fall of 2015 when our daughters started kindergarten together, and they were instantly the best of friends. play dates, birthday parties, sleepovers, balloon races, trips to the lake. To say that it was devastating to our family, in particular my daughter, goes to say the least. When I think of the evolution of safety, it's constantly improving and evolving in other areas of our lives. And I'll date myself here, but when I think of even like restraints in vehicles, right? You know, it started with lap belts, then shoulder belts. And how about the car seats for infants and toddlers compared to what I was brought home from the hospital in? Holy cow, compared to today. And now latch systems. And so I just feel strongly that if we have this awareness that there is a danger that's out there and there is an opportunity to create these safety mechanisms and put them in place, then children like Lizzie would still be here today. She'd be a freshman in high school now. And instead of sleepovers and soccer teams, they'd be getting ready for school dances and going to the basketball games and all of the fun. So we do have a responsibility to protect children, and I thank you for your time.
Good afternoon. My name is John Schaefer, Jonshaffer. I'm from Minden, Nevada, and I'm a father of a 6-year-old and a 9-year-old. And as a parent, we have our own personal responsibilities that we layer upon our family. And but then we also have I guess what we would call safety precautions that we want to have in place. In my prior life, I was a Black Hawk helicopter pilot in the Army. We have operator's manual, safety precautions that we take. This is a unique piece of equipment. We don't want things that be so onerous in society that, you know, we're completely hamstrung. But with a unique piece of equipment like this that people are not commonly familiar with how to operate, this is just common sense approach to applying a few parameters here on how to operate it properly and to keep your family safe. Thank you.
You may begin when you're ready.
Thank you. Hi, my name is Cherie Paprich Hess, Sherii, last name Paparich hyphen Hess, Hess. I had the opportunity to meet Lizzie when she was 6 months old. I remember her first day at Gymboree. I own Gymboree Play and Music, a children's gym in Reno. And the family has just always held such a special place in my heart. They are a service family. They really do look out for people. They are such a wonderful part of the community. And I support this bill so highly that we need business owners that are going to be held accountable. As I do own Gymboree Play and Music, I hold myself accountable for everything that happens in my site and the safety of the children. I personally do not think it's too much to ask a bounce house operator to stay there the entire time. That is their business. They are getting paid to do that. I stay at Gymboree every time I have something going on there. I think it's vital. If you are owning a business, you are responsible for that. I also think we should really work on educating the parents as well. Parents don't always know that a bounce house is made for kids 6 and under, so posting those rules is very important to help educate the parents as well. And I just really appreciate you guys helping so that this does not happen to another family. It is just so tragic that Lizzie had a beautiful, beautiful life ahead of her, and she would have made such a difference in the community. So thank you.
Hello, my name is Kenneth Quirk, Kennethquirk. I am the general manager of Lincoln Heating and Air. As an HVAC contractor, that's heating, ventilation, and air conditioning. I work a lot with air, and I think a lot about air, moving it and heating it and cooling it, and I realize that most normal people don't think about air that much. So Wendy mentioned in her story that she had some thoughts about air, but I think it'd be extremely common that people going into this situation wouldn't consider the danger. And they've hired someone to provide this service. And I know for heating and air conditioning, we are responsible for the safety of the situation from beginning to end. And I think that should be the same with the contractors providing services for bounce houses. someone said earlier, someone was responsible, and I agree. I think that should be the person providing the service. Thank you.
You may begin when you're ready.
Thank you, Chair. My name is Colleen Andres, Colleenandres. My husband served in law enforcement with Mitch. I just recently retired from the military, and I thank Wendy for giving her story, because I know it's not easy. But I want to take the opportunity for you to be in Mitch's shoes when he was out of state trying to support his country. He had no answers to what had happened to his children. And he did everything he could to get back as soon as he possibly could to support his family when it shouldn't have happened in the first place. So think about that. We all hate airports. Think about that. Think about trying to get home to your family when you don't have answers. The picture that you saw earlier that Wendy showed you was at my wedding, and this happened, I believe, a week after my wedding. To this day, we still do not have a wedding picture in our house because I can't go through the pictures. It's that hard. So I'm sorry to waste your time, or not. I know I'm not wasting your time, but I'm sorry that I wasn't prepared for this, but I did want to put that in your heads. Something has to happen here. Thank you.
Thank you, and there's nothing to apologize for. Thank you for being here. Go ahead.
For the record, my name is Haley Hayden. It's Hayleyhayden. I'm speaking on behalf of myself, but I am familiar with the Hammond family through my work with Donor Network West. I work with in community engagement. Donor Network West was the organ procurement organization that worked with the Hammond family on that fateful day. I have been very fortunate to get to know the Hammond family through my work, and they are incredible advocates in so many areas in this community. But just as a community member, I remember when this happened 6 years ago. It was before I was working with Donor Network West. I've worked in nonprofits in the community for the last several years, and it was something that shook this community to the core. I have 7 nieces and nephews that live in this community, and I know that one of my sisters was very concerned when this all happened and very invested in their story. And so I am in full support of this bill being passed, and just wanted to lend my voice to that.
My name's Felicia Hill, Feliciahill. I did not have the privilege to meet Lizzie, but Wendy and I have a connection of that not a lot of people want to have the connection of. I lost my 6-day-old daughter, and she was an organ donor as well. So we are in the community involved with organ donation together. I personally support this bill because there is not a lot of education except for when they started their foundation and started educating the community. I personally didn't know about bounce house safety, and that's on me as a parent and for allowing my child in bounce houses, children, when I'm unaware of different wind speed and all that kind of stuff. But I really want to see, I wasn't able to read the bill, but I want to see more people held accountable, criminal action, different stuff like that, because I personally worked for a local bounce house company even this last summer, and it pained me to see that they just wanted their $5 for 5 minutes of fun. And it is not fun when all of us have to go through this kind of pain as a community, and the family members and the trauma. And I was checking the wind speed, and it was my very first time working for this company. And I told them, like, I don't think we should be having this anymore. And they were like, oh, the event's over in like 15 minutes. Next $5, next $5. And that is unacceptable because lives are not worth money. And so, like I said, I wasn't able to read it. I don't know what kind of criminal action people will be held accountable for, but I'd like to see that a part of the bill if it's not. And I just wanted to voice that because it's all about money for some people, even though they say that they are for safety, and this was a licensed company and different things like that. So Also, if you see something, say something. Like, if you see that those anchors and weights aren't there, then please let someone know. So thank you.
Thank you.
My name is Linda Miller, Linda Miller. I was Lizzie's 4-H leader. Lizzie raised dairy goats, and she was very passionate about her goats. I wanted to thank you, especially bringing up the wind speeds on this. I live in Washoe Valley, so I'm very familiar with wind and how fast those gusts come up. 10 miles an hour is basically a breeze as far as we're considered out in the valley there. But once that hits that 20 miles an hour, it's gust time. You never know when it's going to go from 20 up to that 50 mile an hour mark. So I would truly hate to see it raised up to that 20 miles an hour. But I am strictly in favor of this bill. Thank you.
Thank you. Is there anyone else in Carson City wishing to give testimony in support? I don't see anyone. Is there anyone in Las Vegas wishing to give testimony in support? Broadcast, is there anyone on the phone?
If you would like to testify in support of Assembly Bill 198, please press *9 to take your place in the queue. Caller ending in 997, you are unmuted and may proceed when ready.
Hi, my name is Sierra Norris, C'*ERA, last name Norris, Norris. I am a business owner of a soft play and bounce house company here in Las Vegas, Nevada. And ultimately, I am in support of this bill with a few revisions. As a responsible operator, we always put out sandbags in our bounce houses. We often don't use stakes just because a lot of times we are in backyards, and that is not something that homeowners essentially want to ruin their backyards. In addition, we do not have a operator there at parties. A lot of times it's family-oriented parties, and it's very easy to shut down bounce houses. So that clause seems a little unnecessary, but however, we do fully appreciate, the Hammond family coming together. We have seen some operators out here in Las Vegas just trying to, start a business, but not putting enough effort around their protocols. So ultimately, we've operated for the last 3 years with no incidents under our protocols. So we are definitely looking forward to some of these regulations moving forward. Thank you.
Thank you. Broadcast, is there anyone else on the line?
Good afternoon, Madam Chair and members of the committee. My name is Dora Martinez, and as a newly blind grandma, all my kids have grown, and I'm a grandma now, and with kids under 3 who are going to be probably wanting bounce house, I wholeheartedly, 100% appreciate the sponsor of this bill and the family. I would also encourage that let's hope that the business will have accessible rules and warning that people like a blind grandma wants to do a bounce house would be able to access that website, and because we cannot read print. So thank you to Assemblywoman Brown May, and I'm so sorry for the loss for the family. Thank you. Have a good day.
Thank you for your testimony. Broadcast, is there anyone else on the line?
Chair, there are no additional callers choosing to testify at this time.
Thank you. We will move to hear testimony in opposition to Assembly Bill 198. Is there anyone here in Carson City wishing to testify in opposition? I don't see anyone. I don't see anyone in Las Vegas. Broadcast, is there anyone on the line?
If you would like to testify in opposition to Assembly Bill 198, please press star 9 to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Thank you. We will move to the neutral position. Is there anyone here in Carson City wishing to testify in neutral to Assembly Bill 198? Please remember to state and spell your name for the record.
Thank you, Chair. For the record, my name is Vincent Guthreau. Last name is spelled Guthreau. First name is Vincent, Vinson. Just wanted to come up in the neutral position to confirm some of the conversations that have been happening around enforcement and local government, that those conversations are happening. As was mentioned, some of this is in the Clark County Code regarding these devices, and I just wanted to sort of lend some context for the committee that those conversations are happening with the sponsor, and we thank the sponsor for bringing this forward. Thank you.
Thank you. Is there anyone else wishing to testify? I don't see anyone in Las Vegas. Broadcast, is there anyone on the line wishing to testify in neutral?
If you would like to testify in neutral for Assembly Bill 198, please press star 9 to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Thank you. Assembly member, would you like to give some final remarks? And if the family wants to give final remarks?
Thank you, Chair. Tracy Brown May for the record. There's not really much for me to add. You've heard this story about Lizzie, the life that we're living every day. I'm honored to wear Lizzie's butterfly today. We are very hopeful that we can continue to move this measure forward in her honor so that no other child or family has to go through what Lizzie's family went through. So I thank you for the opportunity. Mr. and Mrs. Hammond, would you like a closing comment?
It's Mitch Hammond, MITCH, HAMMOND. Just want to thank you for listening to our horrific story. And just know that I'll never have my daughter back. It breaks my heart. Please pass this.
Thank you again to your entire family and all friends that are here in support. We really appreciate you. I will now close the hearing on Assembly Bill 198. I will now open up for public comment. Please address your remarks to issues that fall within the jurisdiction of this committee. Public comment is limited to 2 minutes per person. Public comment may be submitted in writing to the committee up to 24 hours after our adjournment. Please remember to state and spell your name for the record. Is there anyone here in Carson City wishing to provide public comment? I don't see anyone. I don't see anyone in Las Vegas. Broadcast, is there anyone on the line wishing to give public comment?
If you would like to provide public comment, please press star 9 to take your place in the queue. Chair, the public lines are open and working, but we do not have any callers to provide public comment at this time.
Thank you. Committee members, are there any comments before we adjourn? I don't see any. This will conclude our meeting for today. We are adjourned.